Criminal trials are where constitutional rights meet courtroom reality. I'm Lisa Rodriguez, criminal trial specialist with 15 years defending constitutional rights in New York courtrooms, and I'm going to show you how to protect and exercise your fundamental trial rights when your freedom is on the line. The Sixth Amendment guarantees your right to a speedy trial, but what constitutes speedy is defined by New York's CPL 30.30, not your sense of urgency. Under this statute, the prosecution must be ready for trial within specific time limits: 90 days for felonies, 60 days for misdemeanors punishable by more than 3 months, and 30 days for other misdemeanors. But here's the critical detail. Not all time counts toward these limits. Periods of delay caused by the defense, court congestion beyond prosecution control, and certain procedural delays are excludable. The prosecution gets credit for time when they're ready, but you're not. Common excludable delays include defense motions, psychiatric examinations, DNA testing, and periods when defendants are unavailable due to other proceedings. Understanding what time counts is crucial because CPL 30.30 violations result in case dismissal, not just faster trial dates. From my trial practice, I can tell you that successful CPL 30.30 motions require meticulous record keeping.
Document every adjournment, who requested it, and the stated reasons. Prosecutors often claim excludable time that doesn't actually qualify for exclusion.
Your right to trial by jury applies to all crimes punishable by more than 6 months imprisonment. In New York, that means virtually all misdemeanors and all felonies. You can waive jury trial and proceed with a bench trial before a judge, but this decision requires careful strategic consideration. Jury selection in criminal cases differs significantly from civil practice.
The prosecution and defense each get unlimited challenges for cause when jurors demonstrate actual bias or inability to be fair. Peremptory challenges are limited, typically 20 for each side in murder cases, 10 for other felonies, and 3 for misdemeanors.
During voir dire, we're looking for jurors who can fairly evaluate the evidence and apply the presumption of innocence. Watch for jurors who seem prosecution-friendly due to law enforcement connections, crime victimization, or strong law and order attitudes that might prevent fair consideration of defense evidence. The burden of proof in criminal cases is proof beyond a reasonable doubt, the highest standard in our legal system. This means the prosecution must prove every element of every charge to a level where reasonable people would not hesitate to rely on it in making important decisions. Here's what juries often misunderstand. Reasonable doubt doesn't mean all possible doubt or beyond any doubt. It's the doubt that would cause reasonable people to pause before acting. As defense attorneys, we must help juries understand this standard without appearing to diminish its significance. The presumption of innocence is more than a legal technicality. It's the foundation of our criminal justice system. Defendants don't have to prove their innocence or present any evidence at all. The prosecution bears the entire burden of proving guilt beyond a reasonable doubt. Your right to remain silent at trial is absolute. You cannot be compelled to testify, and the prosecution cannot comment on your decision not to take the stand. The judge will instruct the jury that they cannot draw any negative inferences from your silence. But the decision whether to testify is often the most difficult strategic choice in criminal defense. Testimony can humanize you and provide explanations for seemingly damning evidence, but it also opens you to cross-examination and potential impeachment with prior convictions. If you do testify, the prosecution can impeach you with prior felony convictions from the past 10 years under Evidence Rule 609. The court balances the probative value against prejudicial effect, but prior convictions for crimes involving dishonesty are usually admissible. Your right to confront witnesses means more than just being present during their testimony. It includes the right to cross-examine prosecution witnesses, to challenge their credibility, and to explore their biases, motives, and memory problems. The Confrontation Clause also limits the use of hearsay evidence. Testimonial hearsay, statements made in formal proceedings or to law enforcement, generally cannot be admitted unless the witness is unavailable and you had a prior opportunity to cross-examine them. This creates particular issues with forensic evidence. Lab reports, ballistics analyses, and other scientific evidence often constitute testimonial hearsay, requiring live testimony from the analyst who conducted the tests, not just supervisory personnel. Jury instructions are crucial to protecting your rights at trial. The court must properly instruct on reasonable doubt, presumption of innocence, and the prosecution's burden of proof. Object to inadequate instructions and request specific instructions that protect your constitutional rights. During deliberations, jurors sometimes ask questions that reveal misunderstanding of their role or the legal standards. Monitor jury notes carefully and object to any responses that might undermine constitutional protections or suggest burden shifting to the defense. Verdicts in criminal cases must be unanimous in New York. If even one juror has reasonable doubt, the proper verdict is not guilty. Hung juries result in mistrials, giving the prosecution another opportunity to try the case, but also providing additional preparation time for the defense. My final trial advice: never forget that you're fighting for someone's freedom, not just winning a case. Every constitutional protection exists because experience has taught us that liberty requires vigilant defense against government overreach. Prepare thoroughly, advocate zealously, and remember that reasonable doubt isn't just a legal standard, it's the barrier between freedom and wrongful conviction in our imperfect system. Professor Legalis will now explain how sentencing works when trials don't end in acquittal, and how understanding sentencing options can influence trial strategy and plea negotiations.